beginning, they can go and watch the recording. That's my cue. So we are going to be recording this. It'll be available on our website. So good afternoon. Welcome to this webinar on this important and timely topic of how to appeal Medicaid terminations in Florida. My name is Lynn Hearn, and I have the privilege of serving as an attorney with the Florida Health Justice Project. I'm coming to you today from frigid Tallahassee. I'm joined by two of my colleagues on this webinar, Miriam Harmatz and Katie DeBreer, located elsewhere in the state, hopefully where it's less frigid. You'll be hearing from them in this presentation as well. A few housekeeping items. We already talked about it being recorded. We ask that if you have any questions, please put them in the Q&A, and time permitting, we will answer them at the end of the presentation. I'm going to read out the CLE number now, but don't worry if you don't have a pen. It's actually on the last slide of the presentation, and it's available on the website. You can get it other times and places. 2313762N. 2313762N. Also on the last slide and on the webpage for this presentation is a link to a really brief evaluation form, and we really would appreciate it if you could complete that for us. It helps us to know if we're doing these in a way that is helpful to you. If there's other topics that you would like to see addressed, it would be very helpful. So with that, I think we can go ahead and get started with our content. So we are here today to talk about the same things that were on the registration form, so they shouldn't be any surprise to you. First, I'm going to give a little bit of an introduction as to the redetermination process that's happening now, that's special and different than the ordinary annual redetermination process that DCF undertakes. And they're doing this as a result of the end of the public health emergency. Next, we're going to actually look at a DCF notice in great detail and study all of its components. You might think that it's straightforward, but it's not. And we've learned a few things and gotten a few tips over time from looking at them, and we'd like to share those with you. Then I'm going to turn it over to my colleague, Miriam Harmatz. She's going to talk about how to figure out if it's appropriate to appeal at all, because not every termination warrants an appeal, right? So she's going to help explain how you go through that process and the tools that are available to determine whether you should appeal. If you determine that you should appeal, she's also going to talk about how and when to file an appeal. Again, you might think it's straightforward, but there are some tips to this process that we have learned that we would like to share with you. And then she's going to pass it over to Katie DeBreer, who is going to talk about how to prepare for the actual hearing and what to expect at and after the hearing. So by way of background, probably everybody here knows that Medicaid eligibility was required to be determined annually, has always been required to be determined annually. But what's different now is during COVID, federal legislation was passed that required all states to keep people on Medicaid whether or not they remained eligible. And this was really important, that people had access to health care during a public health emergency. That was not the time for them to be losing health care coverage because they were a dollar over income. And as it turned out, more people were under income than over. So the states did get extra money in order to maintain people on Medicaid, maintain their Medicaid coverage. But so for 3 years, we were adding people to Medicaid. All the states were adding people to Medicaid and not having anybody come off. Now, they may have been doing the redetermination process. People may have been getting notices, and I don't know if they were actually completing the renewal process. But even if they weren't, they were not being terminated. Or if they were, in the end, the calculation was that they were ineligible, they were still not being terminated. So as a result, during that 3-year process, Florida's numbers went up by almost 50%. So we have our rolls definitely swelled. We had a lot more people on Medicaid than we did before, and people were expecting, a lot of people didn't understand why they had it, and that now they were at risk of losing it. So starting in 2023, states were allowed to discontinue the continuous coverage. Florida resumed its redeterminations and terminations at the earliest possible date allowed under the federal legislation, which was April of 2023. So who was the most affected by this loss of Medicaid after having had 3 years of continuous coverage? A lot can happen in 3 years, right? Anybody who had a 19th birthday, 19th 2021 birthday during that 3 years lost, if they were eligible for family-related Medicaid, they lost it by virtue of becoming an adult. So that's a lot of people, actually. When you look at the numbers, that's a lot of who is being affected. They may be eligible for other types of coverage now under a different category, but that's a process that we have to go through and analyze. The parents of those children who had a 19th birthday over the last 3 years, they no longer have children under 18. It's very difficult for parents to get coverage in that category, but some did, and they would have lost it if they no longer have children under the age of 18. Then we have children who are still under 18, but their family's income has increased. So we'll talk a lot about the fact that the eligibility for children is very different, and the eligibility levels, the income eligibility levels, are much higher for children than they are for adults. So even if the income of the family has increased, that doesn't necessarily mean the child is losing coverage. Also, there are different eligibility levels for different ages of children. So this is something that has to be looked at very carefully. Aged and disabled individuals that are now on Medicare, again, people had birthdays, they turned 65, they may have been on, had full Medicaid up until the time that they were eligible for Medicare. Now they're eligible for Medicare, or people who have been deemed disabled by the Social Security Administration. They have a 2-year waiting period to get on Medicare. It was happening during the continuous coverage. Now they are losing their full Medicaid by virtue of the end of the continuous coverage. And so we need to take a look and see what what options are available for them. And then the last category is pregnant and postpartum individuals and newborn babies. They are eligible for Medicaid coverage for specific time-limited periods, which were suspended or extended during the pandemic. And so they are losing their coverage under those categories as we go through this redetermination process, and there needs to be an evaluation of whether they are eligible under any other categories. Now, these are the categories, the above categories are the ones that we identified as most affected, and they certainly are, but we've seen lots of people in lots of other categories as well. We've seen people in the long-term care waiver, people with medically complex children. There's just no shorthanding for the type of people that are affected. There's a lot of people and a lot of categories that are affected, so everybody deserves a careful look. So in total, we showed earlier that our rolls had swollen to 5.8 million. Now, we just got December numbers, they're down to 4.9. Now that's a net number. You see the title says that there have been over a million Floridians terminated, and that's true. The net number is a little lower than that because people are still coming on, even while they're coming off. So over 1 million Floridians losing coverage is concerning, and something that needs to be given a careful look, and more so because look how many children are being affected. Now, children do make up almost half of the Medicaid enrollment, and that's because Florida has not expanded Medicaid to low-income adults, and so it is more of a child's program than it is an adult program. But we would not expect children to be coming off at the rate that they are, because the eligibility levels are so much higher. And Miriam's going to talk about other reasons related to continuous coverage that we shouldn't be seeing children come off. So these are concerning numbers. So you get a termination notice and you think, well, that was nice while it lasted. Maybe the government's probably right, and I I guess I'm just out of luck. Or another very popular view is I'll just reapply. They made a mistake and I'll just do a new application. We are not fans of either one of those paths, of just kind of shrugging and accepting it or filling out a new application. And there's some very good reasons for that. First of all, Medicaid is complicated. I'm sure everybody on this call knows that. But what it means is that there's just so many opportunities for errors. Errors by applicants. Yeah, sure, you can click a wrong box on your application. You can, fat finger an income number. All kinds of errors by the applicants can happen, and also same on the DCF side. There can be processing errors, there can be policies that they haven't kept up with and implementing properly. So that leads to my next point, which is do not assume that the decision is correct. In our practice over the last year, we have seen so many errors. We do case reviews and we start at the beginning and try and figure out eligibility in the ways that Miriam is going to explain to you. And we see lots of errors. So we encourage you to do your own eligibility determination. I've already mentioned that the eligibility limits for children are much higher than adults. Also, during an appeal, if you appeal timely, which Miriam will explain, you may be able to preserve coverage. And that's very important, of course, because you can stay with your managed care provider, you can stay with your medical provider while you figure out whether the termination was correct. And lastly, it does preserve the right to recover any out-of-pocket expenses that you may have incurred. Normally, we put the key resources at the end of the presentation. I'm putting them at the beginning because they're so important and we're going to be referring to them. I would say if this is overwhelming to you, just look at the top two because the toolkit and the video, we think, really collect most of these resources and provide links to them. The toolkit featured there and the picture there is our second edition, which is brand new, coming out today. Very excited to share that with you. It's a graphic product, much easier on the eyes. And we think that it's very helpful. And basically the content that we're presenting to you today, it's all in the toolkit and more because we couldn't cover it all in an hour. And then I would also just highlight the last resource, which is our referral form. We don't handle many appeals at all ourselves. We're just too small to take on cases, but we definitely do eligibility determinations on behalf of people with other advocates. We're happy to take these referrals from other lawyers, from people directly, from family members, just to help you look at it and make sure, back to the earlier slide, do your own analysis, make sure that you understand why you are or are not eligible. Okay, launching into the Notice of Case Action, affectionately known as a NOCA. I'm sure you've seen these. The main thing, well, yeah, of course you need to know the date. You need to focus on the date. This one here is ending on June 30th. But you also need to look at the whole notice. This is one page. I've seen them as long as 10 or 12 pages. They have food assistance mixed in. They have for some family members, some for other family members. What I do when I'm looking at a long NOCA is I take notes and I list the individual family members and then the program, and they're talking about Medicaid here, they're talking about medically needy here, and also dates, because usually if they have multiple sections, they're referring to different periods of time. And so I just make separate notes about what is happening. You really have to study it. And then you have to focus on the reason. This one says your Medicaid for this period is ending. That is a common reason code that is being used. Obviously, it doesn't tell you anything. So this is another reason you have to do your own eligibility analysis. And the law that supports the action is blank, so you can't look that up. I mean, you want to look at that reason code and see if you can glean anything from it, but often you won't be able to. Sometimes it will say, this one says your benefits will end. Sometimes it will say your application/review is denied, but you already had Medicaid and you weren't aware that you reapplied. Well, maybe you filled out an application for food assistance and they treated that as which you have to do every 6 months, and they treated that as a Medicaid renewal. So that actually is a termination, even though it doesn't have the magic words, your Medicaid benefits will end. It is a termination, and it is subject to all of these provisions that we're talking about today. The only other thing I'll mention on this is another reason code we see a lot is you are receiving the same type of assistance from another program. We get questions from people. Am I really losing Medicaid? Yes, unfortunately, you are losing Medicaid. There is no other program. We're not sure exactly what triggers that language, but you are losing Medicaid. It is a termination, and it is eligible for appeal. And speaking of appeal, this is the magic language that gets you into the appeal arena. This is what brings us here today. This is at the not the very end, but late in the NOCA. It's after the page of QR codes. There's a few things that we want to just point out to you. It says that you have to ask for the hearing by writing, calling the call center, or coming into the office within 90 days. That's not true. You can do those things, and Miriam's going to talk about those, but there are better ways, and she's going to explain that. It also says that your benefits may continue if you ask for the hearing before the effective date. In fact, with Medicaid, they have to continue. That's in federal regulation. So know that, and that's an important reason to appeal. And finally, it says you may be responsible to repay any benefits if the decision is not in your favor. That can be daunting. It used to say you will be responsible, and through some advocacy on our end, gladly, it was changed to may, but that's still probably disconcerting to some that there may be a situation where you're responsible for repayment. You need to know that that's only if there's been a separate finding of fraud or an intentional violation. So rest assured that if you're not engaging in fraud or an intentional violation, you will not be asked to repay even if you lose. So next, I'm going to turn it over to Miriam to talk about how to decide whether to appeal.
Well, the obvious question is, was the termination correct? And because Medicaid eligibility is not always obvious, as Lynn said, FHAP has some tools. And one of the tools I'm going to talk about is the video, which we created to help people determine the income eligibility for different family members. The video also provides an overview of Florida's Medicaid program. It explains that people have to have what's called a categorical connection to either family-related Medicaid or SSI-related Medicaid, and describes the programs that people could be eligible for when they use full coverage, like medicine needy. We're going to be updating this. This is 2023 based on the 2023 poverty limits, and which have gone up. Florida always has a delay in when they implement that, but usually it should be around February. So stay tuned for that. Next slide. And the video is it's separated, it's timestamped. You don't have to listen to me droning on for the full 20 minutes. You can go to the content you want to hear, and most of that that's relevant to this determination is there at 3 minutes and 21 seconds, including the income chart, the one that Lynn shared, and some key tools for figuring out what the household's income actually is. And that's the DCF guide, ESS program policy manual, and the National Health Law Program MAGI guide for advocates. And the next slide, please. So the video goes through how you calculate the income limits for different household members. And as Lynn said, that changes based on the age of the household, the family member. So as you can see here, young infants have a higher income limit. It gradually goes down as the child ages, and then when they turn 19, it drops off a cliff, and they're at the same very low income level as parents and caregivers. So let's look at an example of, you've got a termination notice from a family. It was back in December 2023. They have 3 people in the household. including a 4-year-old youngest, an older sibling, a parent. And let's look for the 4-year-old. And it said, the notice just said Medicaid's ending for everybody in the household, lists them all, and gives a reason as you're over income. And the video demonstrates how you move starting from the left, where you look at household size, which is 3 circled there. And then you move to the right to the coverage group, that's children 1 through 5. You're looking at a 4-year-old. And the coverage group's income is pegged to a percentage of poverty. For that group, it's 133%. So circled that. And then you add the relevant disregard, which we're not going to bore you with today, what those mean. But here you have a standard disregard for kids that age, 145, and a MAGI disregard of 104. And the next slide shows how when you add those 3 together, you see that the income limit is, for the 4-year-old, $3,005. So if the family's income is less than that, and they were terminated, an appeal should have been filed on behalf of the 4-year-old. And this is, and next slide is the shorthand chart. That's a very useful tool. I have it printed out, use it all the time. But I just wanted to note that it can be off by $1 because you're using poverty percentages and rounding up and down. So here it gives it as 3,004. So if the family's income is close, you want to go through that calculation and make sure you have it exactly. Next slide, please. So as Lynn said, their BCF can have some errors in their calculation. And one of them is they were using outdated or incorrect information. For example, if they're including income that should have been excluded, like child support or SSI, or they're counting the wrong household size of the next bullets, and that's mistakes can be made there. Sometimes a 22-year-old who's living in the household wasn't counted, and that can change the calculation. Thinking back to that example, if it had been a household of 4, the 4-year-old would have been over income. And then another error that we've already seen is in the failure to provide continuous coverage. And we've seen it for new moms who are entitled to 12 months of postpartum coverage, and they're being terminated, or even pregnancy, right in the middle of their pregnancy, which should be also continuous. Even if the income goes up, seeing new pregnant women have been terminated. And this is a news flash. Children now have a right under federal law passed at the end of last year to 12 months of continuous coverage. And I just want to underscore that. That's effective January 1. And what it means, so now if you have a child who was on in January on Medicaid under 19, or you're helping a family who got a termination notice and there's a child under 19, and that child was covered as of January, even though the family income went up, they should maintain coverage for a full 12 months. So that should be appealed. And if you have the opportunity, we very much appreciate it at FHJP if you can let us know, so we can be a part of the information loop with the state on alerting that this may not be have been completely incorrectly programmed, like we've seen a good number of postpartum new moms being not able to get their full month's coverage. And next one is a big issue. It's when the state, before they can terminate Medicaid under one category, and we're talking mostly about most people in Florida who get Medicaid get it because they're in a low-income family, and they're losing because for a variety of reasons, like Lynn went through, no longer a minor child in a household for a parent, or income went up and the parents and 19, 20-year-olds are no longer eligible because Florida's level is so low for adults. They may be disabled. A lot of people are disabled. And I know from the registration list that a lot of you all do disability work. So you know that once Social Security makes a determination, DCF is going to stick to that unless one of the exceptions under the federal regulation apply. For example, if the Social Security Administration did not consider all the disabling conditions a person has. And the toolkit goes into that scenario and others at length. And finally, another issue is when people did not get the right Medicare savings plan. And we're seeing those for people over 65 are now on Medicare. And then application errors, like Lynn mentioned, somebody applying for Medicaid or renewing may have hit the wrong key and not even know that happened until after they appeal. So next slide, please. We have on our stories website some examples of people who have been erroneously terminated, a lot of them. And it's alarming how many errors are made, given we don't, as Lynn said, we're relatively small, but we've seen a good number of referrals and a high percentage had errors. Or basis for appeal. So here's Dylan, not his real name, a young man, severely disabled, needs daily medication in order to survive. And he was getting family-related Medicaid. But during the moratorium, during the pandemic, he turned 20, 21, then 22. And when he was renewed at age 22, because he's no longer in that coverage category, and he doesn't have minor children of his own, his Medicaid was terminated. And because he is disabled, FHJP and his situation was so dire. This is one of the few appeals we have undertaken. And the basis for that was that, again, DCF did not had an obligation to do their own independent disability determination because SSA had not considered all of his disabling conditions. And then Lily, a woman 7 months pregnant, terminated, and what she went through in order to get back on Medicaid. Lindsay, an example of she was 2 months postpartum, and she and her 4-year-old also terminated, again, errors that took a good deal of effort to correct. Next slide. So the next issue is, okay, you got one of those people like Dylan or Lindsay or Lily, or you're happening into your family. When do you appeal? You want to appeal as soon as possible. And I just want to note those 2 dates that in the from the sample notice NOCA that Lynn shared. And the first thing you want to look at is appealing before the termination date, that circle down at the bottom, June 30, and that triggers your right to continuous coverage pending the outcome of the appeal. I think the termination was incorrect. But you still have a right, even if you miss that, to appeal within 90 days of the date of the notice, June 19th in this case. And next slide. And how to file an appeal. So the best way we highly recommend is sending your own email. You get to maintain a record. You can send it to the email address on the slide, and we also have a template in the toolkit that has all the information you need to provide. And I just want to flag a couple of things that are important. If you don't indicate that you want to have the hearing in person or video, then the default is to a phone hearing. And that's probably not in your best interest. And you want to include your mailing address as well as email, because the correspondence comes through snail mail generally. Next slide. The other second recommended choice is the online link that DCF has, but it has a section of it that says asks why you disagree with the action. And as Lynn pointed out, a lot of times you don't even know why you're being terminated, because the code will say the reason code your Medicaid for this period is ending. And you should not need to explain why you think it is wrong. So the email on your own is the recommended one. And the next slide lists the ones that are in the current notice of appeal, notice of termination, that we do not recommend. That in that language, they are the only ways you can do it. Calling the DCF call center. Well, we have a lot of evidence, both anecdotally and database, that show that it can be very hard to get through to the call center. Going in person also problematic, and many people can't do that, and there aren't that many DCF offices to go to. And the third way that the notice now says you can file an appeal or request for a hearing is by US mail. And that's a big problem, especially if you're trying to appeal before the termination date, because it may not get there on time, you don't have a record, mail can be lost. So next slide. And again, maintaining benefits is very important. It is required, but it doesn't always happen. Medicaid is not self-executing. So what do? If you've got to be proactive. One thing is check your access account. The next thing is you want to make sure that you call your DCF contact, that their name will be on the notice that you get back to state. Next, you even if DCF says that your benefits have been restored, but you hear from your doctor or the pharmacy, we don't see coverage in our computer, then contact ACA. Here's their helpline number, also in the toolkit, and file a complaint with ACA. And we have materials on our website about, and the toolkit, how to do that. And also you can file a motion to reinstate coverage pending appeal, which is a really important strategy for people who critically need the care. And again, there's a template in the toolkit. And next slide is a final warning that you might get a note that, and after you file your appeal before termination, saying Medicaid's been restored, do not use that as a basis for withdrawing your appeal. It may have been triggered because you were put back on coverage based on your right to stay covered pending appeal, but that doesn't mean the problem has been resolved. And so you need to make sure that you check your access account and ensure that there's been a full year of indicated as your entitlement to coverage. And now I'm going to turn it over to Katie DeBreer to cover what happens next.
Hi, everyone. Thank you for joining us today. And just before I get started with my section, I noticed, Miriam, there was one question in the Q&A for you that I think ties well into my portion of this presentation, which will be about preparing for and going to the hearing and what will happen after. And that question was whether or not you could upload a hearing request into Access. And the answer to that question is no. Not only that, but I would not recommend that particular approach to requesting a hearing, because we have found anecdotally that a significant amount of the documents that are uploaded into the Access system are not actually reviewed. All of those documents have to be manually reviewed. And so you would be relying on a human being on the other side of the Access portal to take that hearing request and input it into the DCF Office of Appeal Hearing System, which is a different arm of DCF from Access. So again, we would not recommend that approach, and that approach would in fact not work in order to request a hearing. So as Miriam said, email really is the best way. The second option would be submitting through the online link on DCF's website and maintaining proof. That's a theme that we will carry throughout this presentation and also throughout the advocates toolkit. Maintain proof of any and every interaction with DCF. So thank you for letting me slip that into my presentation. I'm going to talk about what you do to prepare for the hearing, what you do after you file your appeal. So according to DCF procedures, you may get a call shortly after filing your request for hearing. DCF procedures say within 3 days. I will say in my own experience, I do not get calls from DCF to discuss the foundation of the appeal, but we have heard of it happening. You want to be prepared, and you want to take that phone call if you receive it, or call the individual back, because the purpose of having that initial call right at the outset of filing your appeal is to resolve the issue. Was there a simple mistake made? Is this something that you can talk through with the DCF case supervisor? And if so, do that. Also take the opportunity to, because as we know, the notice is not sufficient in informing the individual of why the agency, why DCF took the action it did. you can take this opportunity with the call from the DCF supervisor, which is sometimes termed informal conference, to gather some more information about what's going on and figure out on your side how to best prepare for the hearing, show what mistakes DCF may have made if at that time DCF is unable or unwilling to identify the mistakes that you think are at play. What we really want to emphasize here, though, more than anything else on this slide, is that initial call should not be used to talk you out of withdrawing your hearing. So do not take canned or very high-end conclusions about your eligibility as gospel when you're talking with the DCF case supervisor. That's more often than what we find the conversation that occurs between the Medicaid recipient and the case supervisor. Why don't you just dismiss your appeal? You're going to lose because you're over income. Those conclusory statements do not give you the information you need to truly assess whether or not DCF has made a mistake. So again, do not let them talk you out of withdrawing your appeal. Do get information. And then I'll just say, as a little side note, if you're an attorney who's representing an individual on an appeal, what I like to do, whether or not you get this phone call, is I like to immediately reach out to DCF Regional Counsel and start a conversation about how we might resolve the case. I think more often than not, you'll find that DCF Regional Counsel is really motivated to resolve the case because they're concerned about their employees and the bandwidth they have to handle all of the responsibilities they do. So I find that they're really willing to work with you to identify and fix mistakes. So starting that conversation, obviously, right after you file the appeal or even before is a good approach. Next slide, please. Okay, so the main takeaway, I try to have a main takeaway with every slide. And this slide, it would be everything that you're going to get after you file this fair hearing request via email or online. You would think then you're going to get responses via email or online, but no. The big takeaway here is all communications through the DCF Office of Appeal Hearings will be sent and received via US mail, snail mail. So one thing we recommend is to keep all of, not only obviously the information that DCF Office of Appeal Hearings provides to you about the appeal, which I'll review in just a second, these bullets here on the slide, but also keep the envelope, because the envelope is going to have the postmark date. And if you get a notice scheduling hearing that is very close to the date of the hearing, or sometimes even after the hearing, which I had heard of particularly during COVID time, then you will have proof as to why you were unable to sufficiently prepare for a hearing. You will have proof as to why you were unable to show for a hearing with that postmark date on that envelope. So the first communication that you will get via US mail from DCF after filing your appeal is the acknowledgement of hearing request. This contains great information, not only about how to contact DCF for the appeal, but also your initial hearing instructions. This acknowledgement is just a standard form, and it's not going to tell you whether or not that hearing has been set, as Miriam mentioned, in person or via Teams or by phone. That's going to be the notice of hearing, but you want to look at that notice of hearing very closely when you receive it. If you have requested a hearing by Teams or in person, to make sure that DCF Office of Appeal Hearings has in fact processed that request. In my experience, I've made the request up front when I request the hearing, but still when I receive the notice of hearing, it's set by telephone. So you're going to need to make sure that you make a request to reset it in person or by Teams. We find that hearings done in that forum as opposed to by telephone really help the flow of information and getting questions answered accurately. So that first communication will be the acknowledgement hearing request, lots of good information in there. Keep the insert in particular, which will walk you through how to prepare for your hearing and who to send information to. And then notice of hearing, you'll get the scheduled date of the hearing. Obviously, you want to put that in your calendar and make sure on top of that date and reread the instructions about when evidence needs to be provided prior to the hearing. And in that notice of hearing, you'll also get the conference call instructions. So again, if you're getting conference call instructions, that means that this is set by telephone. That's okay if that's what you want, but otherwise you need to reach out to the Office of Appeal Hearings and ask that it be done in person or by Teams. I find when you do it by Teams, if it's initially been scheduled by a call, they will keep the same date. Obviously, in person is going to require a little more resource, so they oftentimes reschedule the hearing. Next slide, please. All right, so what kind of information do you need before you go into the hearing? You want to request your entire DCF file. You're entitled to it for free. In fact, any discovery that you do as part of the hearing, you're entitled to copies of those documents for free. One thing I always request when I'm requesting the DCF file is a copy of running records comments. There's some really juicy stuff in running records comments that include, for example, history of case process or actions and the justifications for that for those actions. So all that information that's missing in your notice, the basis, the reason for DCF taking an adverse action against your Medicaid, that may live in the running records comments. You might get a much juicier story of what is going on in terms of the decisions that were made. And then the other thing that is in that running records comments, more often than not, is calls to the call center. So any attempts that the individual has made to give information to DCF to properly process an application. So good stuff in there. Request the running records comments. Don't just rely on what is sent in the fair hearing evidence packet. I'm sorry, let me back up 1 second and go in order. Review the application information on your My Access account. So you've gotten a notice of termination or a notice of denial of Medicaid eligibility. First thing you want to do is go into your Access account, look at that renewal application, look at the initial application, fine tooth comb it, make sure there are no errors, because if there are errors, that's going to be a quick way to resolve the issue of the denial or termination, notifying DCF of those errors. And then obviously, in order to prepare for the hearing, you need to know what rules apply. So I would recommend as a first step, watching Miriam's amazing Florida Health Justice Project video that gives a rundown and an overview of determining eligibility for family-related Medicaid. So pregnant women, children, very young adults, and parents and caretakers. All of those concepts, though, are really going to be very similar to determining eligibility for SSI-related Medicaid, except you have the component of the need for a disability as well as an assets determination. Once you kind of familiarize yourself with the information that you're looking for in terms of what rules apply to your particular Medicaid category, then you can really dig in deep by going into the program policy manual, which is really the only thing that the case processor and hearing officers are looking at when they're reviewing the rules. We as Medicaid lawyers obviously like to cite to the Medicaid Act and Medicaid regs, but the DCF ESS program policy manual is really where the rules live and breathe. And then you can look at the Advocate's Guide to MAGI for family-related Medicaid, countable income household composition rules. And hey, you can also do a referral to us. It's hyperlinked here. We are very familiar with these rules. This is why we exist, and we're here to help you be guided through eligibility. And then, as I was about to say, don't rely on what's sent in the fair hearing evidence packet. If you need to, you want to conduct additional discovery. For example, you have some questions about how DCF reached the conclusion it did. You can put those questions into written form and send them off to DCF to be answered under oath. If you're an attorney and you're watching this, I strongly recommend conducting a deposition, sending out a 30B6 notice. I'm sorry, under state rules, I apologize, under state rules, it's a little bit different, but essentially this is the corporate rep depot notice that lays out the topics that you want to ask questions about. You want to get to the bottom line. Why do I strongly recommend this? Two things. One, obviously, you'll know the position of DCF and why they terminated or denied Medicaid eligibility. But two, in my experience, once that 30B6 notice goes out, DCF is even more motivated to resolve the case, to get to the bottom of the case, prior to that deposition. And I find 9 times out of 10, once I serve that notice of deposition, then the case is resolved and I don't even have to go to deposition. And then I'll just say too, for those attorneys who are solo practitioners, COVID era has really driven down costs on depositions, particularly that they're done by Zoom now, and you don't have to order the transcript. So it could be a $50 to $100, $200 investment at most to resolve the case and save everyone time and additional money. Next slide, please. Okay, so again, in preparing for the hearing, maybe circumstances have changed. Maybe you've determined that potentially the DCF decision was right at the outset, but there's been a change in your income. You've lost income or household composition. Someone's pregnant. Well, guess what? A hearing is de novo, and that means that you can submit new evidence to DCF to determine that the termination or the denial was incorrect. Any of that information, though, should be disclosed to DCF and the hearing officer at least 7 days before the hearing. And honestly, the moment that you learn there is new or changed information, you should be bringing that information to DCF so they can reach the correct determination. Next slide, thank you. Also, in preparing for the hearing, one thing that, particularly as a lawyer, but even pro se at times, I know this is an odd one, but I'd really consider a court reporter if you actually end up going to hearing. You're not going to have a written transcript of the hearing, and if everything goes wrong and you lose your appeal and you need to go to the District Court of Appeal, if there's evidence that's not considered, for example, you're not going to have proof that the hearing officer didn't consider that evidence, that there was no substantial evidence in place if you don't have a transcript. So I consider it to be very crucial. I actually worked with a client who went to a different administrative forum for a Medicaid fair hearing recently, where I made this recommendation, and she said that she was able to secure a court reporter after doing a little bit of a search, because not every court reporter will assist someone who is without a lawyer, pro se. But that it was only $100 for the court reporter to show up and take the transcript by phone. They just required a little payment in advance. So again, if you're getting to the point, which all of the things that we've talked about prior to this, you should be able to resolve before you ever go to a hearing. But if you're getting to the point where you're going to a hearing, we would recommend the use of a court reporter. And then 7 days before the hearing, as we've said, send all the documents you will use both to DCF and to the hearing officer. You can send it to the hearing officer via email at the same email that you send the initial request for hearing to, appeal.hearings@myfloridafamilies.com. The instructions for sending it to DCF directly, their witnesses, is going to be in that hearing instructions you get with the acknowledgement of fair hearing request. But what I would recommend trying to do is reaching out to DCF and getting an email so you can send it that way, as opposed to having to haul down to Office Depot or wherever the case may be to send via fax. Don't send by mail. That to me means it's going to get lost and you'll have no proof of having served it on DCF. And then again, you will have a DCF contact at that point, hopefully. Again, once you have done all of your research, you've done your questions, you've done your discovery, you know what your argument is going to be at the hearing, present those ahead of time to your DCF contact. Try to get this resolved before you go to a hearing. Next slide, please. All right, special situations. So let's say you need some more time to prepare. DCF has kind of dragged its feet on providing you responses to your interrogatories or setting that deposition. You can always file a motion for continuance. Obviously, if you're without Medicaid coverage at the time, this may hurt you a bit because you will continue to be without Medicaid coverage, but you want to weigh that against presenting your best case at hearing, which a continuance might require. If you've stayed benefits, if as Miriam said, you're able to get benefits reinstated if you were terminated or they properly continued benefits, then you don't have to worry about a motion for continuance. You can take all the time you need to prepare for your hearing because you continue to have your Medicaid coverage during the pendency of the appeal. If you need transportation, DCF must provide. And then once you're back on Medicaid, once you resolve, you do all of your research, you do your preparation for your hearing, you identify all of the deficiency in DCF's decision, and yay, you've convinced DCF that in fact you're right and they were wrong. So you're back on Medicaid. You're going to get a confirmation of that through what is just going to look like a standard notice of case action. And then you can file your notice of withdrawal. But caution, warning, just as Miriam said, sometimes you get something that looks just like a notice of case action, finding you eligible. That's just a continuation of the benefits pending appeal. So you're going to want to make sure, either through a conversation with DCF Regional Counsel or your contact person, or even by showing up at the hearing and saying, hey, Your Honor, I got this notice. It says I'm eligible. I just want to put on the record that I am in fact eligible, and this is not a continuation of for benefits. So get that assurance, and then you can file your notice of withdrawal. And don't worry, I realize I'm not giving a lot of legal citations or support for these conclusions, but they are all in that amazing advocates toolkit. So you can look there for that and templates and examples of these pleadings. Next slide, please. Okay, at the hearing, you're at the hearing. Unfortunately, you've been unable to convince DCF that they were wrong and you were right. If it's a termination, DCF goes first. They have the burden of proof. If it's a denial, DCF does not go first. You go first. And that's where, again, circling back to what Miriam Harmat said earlier, make sure, or I'm sorry, Lynn, make sure when you're looking at that notice of case action, even if it says, you know, we've considered your application and we've denied it, may not be a denial. It may be a termination if you had Medicaid and something was triggered to trigger a new application to find you ineligible. So termination, you had Medicaid, you lost it. Denial, you did not have Medicaid, you're applying for it anew and you were denied it. In the first situation, the termination, regardless of what the notice says, if you had Medicaid and you lost it, DCF's going to have the burden of proof. They have to go first. They have to present enough evidence to show that they reached the right conclusion. In order to do that, they're going to bring a witness in. They're going to discuss why you're ineligible, and you get to then probe probe that testimony of that DCF representative. You get to ask questions of that DCF rep. And then you present your case. You put on what you believe the rules of eligibility are and what evidence you have to support your rules of eligibility. And most likely you're going to take some questions from the hearing officer well. So as you hear, you introduce witnesses and documents to support why you believe DCF is incorrect. DCS representative may also ask you questions in addition to the hearing officer, and just do your best to answer the questions truthfully and to the best of your ability. And then if we're in a termination hearing, DCF, after listening to your side of the case, gets to present a rebuttal, gets to present reasons why your side of the case is incorrect. Again, if this was a denial, this order would be switched. Next slide, please. Okay, so it's a termination. DCF's gone first. You've done an amazing job showing why DCF was wrong, both by asking them questions during their portion, then you present your own portion. DCF does not rebut. Hearing is about to conclude. Hearing officer asks, do you have anything left to discuss with us today? This is where I recommend you take a big deep breath. Tell the hearing officer you need about 5-10 minutes and review what has happened in the case, what has been said. Has there been any new issues that you were unaware of that were brought to your attention? A missing document, for example. That's a good time to then request to keep the record open so that you can submit that additional evidence, that missing document, and win your case. And the hearing officers, I find, are always very open to keeping the record open for a reasonable amount of days, 1 to 2 weeks, for you to submit that information. I should also note that the rules allow you to bring anyone into the hearing with you that you would like, both to testify on your behalf if that's needed to prove that DCF is wrong, but also just to act as support. So you can have while you're doing all of the work that you need to do to present your best case, you can have a friend, a parent, a sibling, a colleague, listen in and take notes. And that way, when you're getting to the portion where it's the end of the hearing and you're taking your deep breath before the record closes to find out whether or not there's anything additional that needs to be added. And then particularly if you're counsel who's representing someone who's been terminated, I, in my practice, defer my closing statement and ask instead to submit a proposed order. These hearing officers are not always lawyers, and they are certainly overworked and underpaid. So they, I think, appreciate the connection of the eligibility rules to the evidence that was presented. And if you have a court reporter there, you can always really beef it up, order the transcript, and support your arguments with statements in the record. Next slide, please. Okay, after the hearing, your final order, the hearing officer's final order is due 90 days after your request for appeal was filed, unless you waived it. I just, for the lawyers in the room, want to mention a case, Thompson v. Fitzgerald, 558 F Sup 3rd, 1334, out of the U.S. District Court in Georgia, which very clearly sets out this right to have a hearing decision after 90 days of making the request. They do have to, if you win, yay, congratulations. DCF must comply with the hearing officer's favorable order to you within 10 days. The other thing I want to just quickly mention here is in a managed care, even if DCF, and go ahead, you can advance. Even if DCF complies with the fair hearing officer's order and does what they're supposed to do, which is authorize the corrective action, make your Medicaid eligibility stay to the date that it was first terminated. If you lost it, in some instances, particularly with terminations, hopefully you've continued your benefits pending the appeal, so this is not necessary. But if you lost it, they have to reinstate back to the date of the error. And if you're in managed care, then you're also going to have your re-enrollment process in managed care. What we find is there's usually a lapse between DCF fixing that, if it's in the middle of the month, for example, and getting back into your managed care organization on the first day of the next month, which can prove problematic because you need your MCO to get your care. That's when you file an ACA complaint that Miriam described earlier to make sure that you get into your managed care plan as quickly as possible and start back up your care. And then advance, please. And then one more note, and this is detailed in the handbook, so I'm not going to go into great detail here, but you're absolutely entitled to be refunded both for any out-of-pocket medical expenses you had if benefits were not continued during the pendency of the appeal, and also to have the providers who have any unpaid medical expenses during that lapse in insurance to have them resubmit those claims to ACA. Even if it's outside the 12-month period. So a lot of providers will say, well, we can't bill anymore because it's been a year since the date of service. That is not true if you've gotten a favorable order from DCF. There is an exception, and providers can submit claims 12 months past the date of service. All right, after the hearing, if you lose, darn it, you can appeal to the District Court of Appeal. You need to file your notice of appeal within 30 days. The record is closed. You may not submit new evidence. This is when having that transcript really comes in handy from the court reporter. If this is the issue, and then in order to prevail on appeal, you have to show 1, a finding of fact not supported by evidence, 2, significant error in procedure that affected the fairness of the hearing, or 3, an incorrect interpretation of law on an important issue. 2 and 3, you can really show without any kind of substantial evidentiary record. But 1, again, you're going to need a transcript. You're going to need that full court record in order to prove that the hearing officer didn't consider all of the evidence. This is when, honestly, you should really be talking to a lawyer and assessing 2 things. 1, should I forgo an appeal and just file a new application? Or two, do I have a good argument on appeal? And then do I need to proceed with this appeal because I've had a lapse in coverage and I really need coverage for unpaid medical bills that I can't otherwise afford? That's what we keep coming back to. That's why you pursue appeals, because you want to make sure that you get coverage back to the erroneous date and you're not hit with any unpaid medical bills. And then one last point, if you lose, we're coming back to that fair hearing language that Lynn talked about. You're not going to be required to repay any of these benefits if you continued benefits during the pendency of the appeal, unless there is a separate finding of fraud or an intentional program violation. So if you requested continued benefits because you truly, genuinely believe that you were eligible and it turns out you were wrong, or the hearing officer got it wrong, only with a finding of fraud or an intentional program violation can they make you pay back benefits. And I'll just note that with a fraud or IPV, the agency has to go through significant due process procedures and give you the opportunity to challenge that in a separate proceeding. And with that, hopefully I have not left any room for questions, but I'm happy to stick around for a few more minutes, Lynn, if that would be helpful. And thank you guys so much for attending today.
Yeah, I think we are at time. So if anybody needs to go, that's fine. It won't hurt our feelings if you need to drop off, but we can just answer these quick questions. One was, how do you request a DCF file? Email. It's all a matter of timing. So you will receive that acknowledgement of hearing request somewhat shortly after you have filed your appeal, but it does come via snail mail. That is going to have the name of a DCF contact and a phone number. It does not have an email, but I absolutely recommend calling that person and trying to establish a connection via email. So that is the best way to request your DCF file. And then the other question was, are you hearing about all the troubles people are having creating a new DCF case and getting recertification completed? Yes, we have heard of some problems with the new My Access system. And it seems that if people are, uploading documents and they're not being recognized or they're not able to get on, that could be a basis for appeal. So that is absolutely something to consider, and feel free to reach out to us via our referral line, our referral link, to consider whether an appeal is appropriate. Miriam, did you want to add something to that?
I was just typing in the answer. Two good questions, Megan. I hope you got the other answer. These people are likely being terminated for the alleged the reason given would be failure to timely renew. And if they have, tried and not been able to because of the DCF hiccups in the new portal, I think that that's a basis for appeal. And we've heard about, like Lynn said, we've heard anecdotal reports, but not yet had actual cases. So please do reach out if you have anybody that has been terminated, and we'd love to, go through it with you. And then the other one on medically needed, yes, absolutely. Keep the record of those bills sent, the fax receipts, and if DCF does not apply them to share of cost, that would be a basis for appeal and retroactive coverage.
Okay, well, again, thanks very much for coming, everybody. We would very much appreciate it if you complete the evaluation form so we can get better, and we'll see you next time. Thanks a lot.